For the defendants.
For defendant.
Oh, okay.
Sorry, I didn't see my learning friend on time. I didn't know he has joined us already.
Yeah, I think
we're here.
No problem.
Yes, sir.
Yes, Claimant Counsel, announce your appearance.
And Honorable Bayo Edowu is my name, sir.
Okay.
With me is
Honorable
Bayo Edowu, sir. Yes, sir.
You know, the year has just resumed. We are not yet fast.
Thank you, sir.
This is my first sitting for the year, so let us pick up gradually.
Thank you, sir.
Honorable Bayo Edowu.
Yes, sir.
With
SC Odofin, sir. Esquire.
SC. Yes.
C.
Yes.
Odofin.
Okay.
Yes, sir. Thank you, sir.
For the claimant.
For the claimant,
sir. Yes, sir.
Yes, Edowu, the matter is for what today?
Yeah. Yes, sir. The matter, we adjourned the other time. The defendant said they will come back to meeting with terms of settlement. We waited for them up to today. We have not.
The matter is for report of settlement.
Yes, sir.
Are you sure you are talking about the same case?
Yes, sir.
This matter is for adoption of final written addresses. We adjourned last on the 9th October 2023.
Our own was 23rd of October, sir.
2023.
2023.
This is the case of James Dotie and BGI Aviation.
That's our case,
2018.
No, that is our case, sir.
You say what?
That is our case, my lord.
Let the people in the mat that we are talking with, let them be the ones to respond first now, whether it's the case they are talking about or not first. Okay? Please. Bayo, is that your case?
No, sir. It's our own is Dr. A.T. Odeyemi against the Governing Council of Ekiti State University.
So what do you say?
Yes, sir. The matter is for report of settlement
you say,
today.
Sorry,
sir.
You said this is not your case now.
No, sir, it's our case. It's not
my lord, it's not their case. Mr. Bayo Edowu, it's not your case.
Bayo Edowu, why are you confused this morning? I said the case I am doing is James Dotie and BGI Aviation Technical Services Limited.
No, sir,
it's not 2018. Is that your case? You said no. So what do you say now? Sorry, this is not our case.
It's not our case, sir.
You announce appearance in error.
As God pleases.
Is that the correct position?
No, sir.
What's the correct position?
That's not our case, sir. That's not our case, sir.
So you announce appearance in error?
Yes, sir. I'm sorry, sir. I'm sorry, sir.
I just want to have you on record. Okay, Adiola Omotunde SAN.
Yes, my lord.
Is it your case?
No, my lord.
No. So, so you announce appearance in error?
Yes, my lord.
This is the first case of the year, and we are starting it in error.
Sorry, sir. Sorry, sir.
Okay, the proper lawyer should announce appearance now.
May please, my lord.
Yes.
May please, my lord.
Yeah.
I am Tokwe Timokun. I appear for the claimant, my lord. I am Tokwe Timokun.
Okay, yes.
I appear for the claimant, my lord.
May you please, the Honorable Court, sir?
Yes.
Obafemi Agaba. With me is Irene Momo. for the defendant.
Just wait first. This time around, I have to look at my old records. Be sure whether Obafemi Agaba, yes, with Irene Momo. All right.
For the defendant, sir.
Obafemi. So you people were in court and others were announcing appearance in your matters and you kept quiet.
No, respectfully, my lord. My lord has asked those who were in the courtroom and that their case be called. So, and we thought that was the case that was.
No, that is not exactly how it is, sir. We called a matter first and I said any lawyer in court, that could only relate to the matter called.
Apologies, sir.
Isn't it? Because I had already called a matter. So asking about any lawyer in court is a lawyer in the matter called.
Oh, we are sorry, sir.
Very sorry, man.
Sorry, sir.
Okay. All right, Tokwe.
Yes, my lord. My lord, the matter is for adoption of final written address. The defendant, they have an application.
It's for adoption of final written address. Are you ready?
Yes, my lord, we are ready.
Because I'm going to ask the defendant to talk.
We are ready, man.
Yes.
Yes, my lord.
Obafemi.
Yes, my lord. We are ready to proceed. However, we have an application to regularize our defense, our final written address, sir.
You have an application for extension of time.
Yes, my lord.
Okay. Before we proceed, let me just ask Tokwe a brief question. Have you been served?
Yes, my lord, we have been served. And we
are you opposing the motion?
We are not opposing the motion, my lord.
Okay, good. So let's proceed, Obafemi. The motion is dated. The motion is dated.
The motion is dated the 21st day of March, 2023, and filed on the 22nd day of March, 2023.
Oh, just to see the motion. Is that the motion? Okay.
The motion is dated 21st of March, but filed on the 22nd of March, 2023.
You are saying this. Let me confirm from my file before we proceed. Okay. And filed. No, it's dated what? 21st? 21st of March. Okay. Did you say it is dated 21st March?
Yes, my lord. 21st March dated, but filed on the 22nd.
Okay, 2023.
Yes, my lord.
You move in terms.
As the court places, we're grateful, my lord.
Tokwe, no objection.
No objection, my lord.
Court, application granted as read.
As the court places.
Yes.
Yes, respectfully, my lord.
Tokwe.
Yes, my lord.
Do we go ahead
yes, my lord.
All right. So yes, we start with Obafemi.
Thank you, my lord. My lord, in opposition.
You had the fresh copy of the written address. Copy of the written address besides the motion. Yes.
My lord, in opposition to the claims of the plaintiff, The defendant has filed his final written address dated the 21st day of March, but filed on the 22nd of March, 2023.
So your opposition is the final written address?
Yes, my lord, the final written.
Yes, your opposition to the suit is the final written address.
It's the final opposition, my lord, in summary of our defense, my lord, in the defense of the suit, sir.
Okay, in defense.
Yes, my lord.
Okay, because I would have asked you, okay, so if you have a counter affidavit or a statement of defense, whether that one is in what now?
As the court places,
I think that's the opposition.
That is the
as the
opposition.
court places.
Yes, so your final written address is in support of your opposition.
As the court places.
As the court places.
All right. And deemed today.
As the court places, yes, my lord.
You
Filed on the
adopt.
22nd and deemed today. I adopt respectfully. My lord, we also have a defendant's reply address. The defendant's reply address is dated and filed on the 12th of January, 2024.
On what date?
It's dated the 12th day of January and filed on the 12th of January, 2024.
Yes, you adopt them.
We adopt same and respectfully urge the Honorable Court to find in favor of our submissions and dismiss the suit with substantial cause. We are grateful, sir.
Thank you.
Yes, my lord. On behalf of the claimants, my lord.
That's stop by now.
Yes, my lord. I'm talking to you, sir.
Yeah.
My lord, we file a final written address for the claimant. My lord is dated the 3rd of January, 2024.
It's not, okay, it's not right.
It's dated the 3rd of January, 2024. And filed on the 24th day of January, 2024.
And filed on what date?
I filed on the filed on the 4th day of January, 2024.
Because you are
my lord got me there. Yes.
You are fast forwarding the month. Eh?
Very sorry, sir.
You know, if you fast forward the month, for
Very
those
sorry,
of us who are civil servants, it is good for us to collect our salary quickly. But it means you are cutting short everybody's life by those number of days. Because it means we have already spent those days out of our lives. Meanwhile, we have not spent it.
Very sorry, my lord. My lord is dated the 3rd day of January, 2024, and filed on the 4th day of January, 2024.
Right. Thank you. Yes, you adopt. You adopt?
My lord, we adopt him as our submissions addressed to the court, sir, in order to court to grant the release of the claimant. My lord, sir, we need 2 minutes, sir. My lord, sir.
In adumbration.
Yes, my lord. The defendant, sir, they filed a reply address.
Yes.
In this matter.
Yes.
My lord, I just want to refer my lord to paragraph 2.2 to 2.5.
Let me hear the argument first before we go to paragraph 2.2 to 2.5 of the reply address.
Of the reply address, my lord.
Defendant reply address. Paragraph 2.2.
2.2 to 2.5, my lord, of the reply address.
Yes.
My lord, the defendant argued in that portion
Yes.
that paragraph 24, subparagraph D, E, F, G, H, and N of the DW1 statement or note,
Yes.
which we objected to as evidence. They argued there is an official record of the defendant, and that the witness, as an agent of the defendant, can testify in regard to those portions, even when he didn't witness those portions. What transpired? That is the argument.
Yes.
In this. My lord, we are
Yes.
just submitting to my lord
Yes.
to look at the record of the court, to find we are just urging my lord to look at the record of the court to find
Just a moment. Just a
as
moment. In response to paragraphs 2.2,
2.5,
2.3, 2.4, and 2.5 of
the defendant
defendant's reply address.
Yes, my lord.
We submit that.
My lord, we submit that the depositions, in paragraph 24, paragraph 24,
W1's witness of DW1, isn't it?
yes, DW1, my lord.
Okay.
That the paragraph 24 D, E, F, G, H, I, and N that we objected to in our address.
Yes.
We are saying that they are not official record of the defendant. They relate to a meeting that was held in an hotel. They are not official record of the defendant, sir.
They do not relate to official.
Yeah, yes. They relate to a meeting.
Records of the defendant. Okay.
They only relate to a meeting held in an hotel, sir, my lord. Between 1 and 80, who is not an employee of the defendant.
Yes.
That persons. And that DW1 was not in that meeting. That is our submission, my lord. And secondly, sir.
Don't want me to write it down?
Very sorry, my lord. My largest seniors are waiting. I don't want to be seen as taking most of their time.
No, it's your own space, and you must utilize your own time. You must be listened to properly to ventilate your
I'm very grateful.
Your client's case.
I'm very grateful, sir. Yeah, very grateful.
They will be patient.
Yes.
In fact, they are already patient.
Very grateful, sir. They're very
grateful, sir.
We'll send the file because don't worry.
The Nigerians say, "Na turn by turn." So it's your turn. All right.
Hello, secondly, sir.
Yes.
In the reply address,
look at it.
In paragraph 2.6 to 2.11.
Yes.
In paragraph 2.6 to 2.11.
Yeah.
The defendant argued, my lord.
Somebody is talking. Somebody who is not addressing me is talking, and it is interfering. Please stop. Let only talk. Thank you.
My lord, in that paragraph 2.6 to 2.11.
Yes.
Of the defendant reply address, they argued that the documents we objected to.
Yes.
On the basis of the fact that they were electronic evidence.
Yes.
There was no compliance with section 84, subsection 2 and 4.
Yes.
They argued that even if DW1 did not tender a certificate of identification.
Yes.
They said DW2 in oral evidence identified those documents.
Okay.
My lord, we are saying that in all the record of the court, there is no portion in which the DW2 identified those documents in line with Section 84 of the Evidence Act.
W2 did not identify those documents. Those documents you objected to, isn't it?
Yes, my lord. Their response
in line with Section
84, my lord. Section 84, subsection 2 and subsection 4.
Yes.
Their response was that DW1 did not comply.
Yes, that
But
even if DW1 did not comply, it was DW2 covered the field.
Yes, my lord.
Yes.
My lord, the submission we are making to the court is that.
Yes, we say he did not do that. I've recorded
They didn't do that, my lord.
Yes.
There is no portion.
So it's an issue of how to look at my records.
Yes, my lord. My lord, Section 84, subsection 2, sir.
Yes.
The identification that the Evidence Act envisaged is in Section 84, subsection 2.
Yes.
It is not just to say that I know those documents.
Yeah.
And we are saying that Section 84, subsection 2, my lord, of the Evidence Act.
Yes.
That has to do with how computer produced the document, how the information was supplied to it, and all of those provisions is in Section 84, subsection 2. There is no compliance, my lord. There is no compliance.
All right.
And we are saying that it is that section, my lord, very sorry, my lord, that led to Section 84, subsection 4. That is the issue of certificate. There is no certificate, there is no evidence to comply with Section 84, subsection 2. And we are saying those documents, because they are email, my lord, they should be rejected. That is my last point, my lord.
He said there is no what and there is no certification.
There is no certification and there is no compliance, even by oral evidence, with Section 84, subsection 2, to authenticate those documents we objected to. Another will be all for my operation.
If I'm understanding you, you
Yes,
are putting up the argument and which agrees to the position that it is either they could have provided the certificate of compliance, or they could have included their compliance in their oral evidence, and that they did none of these two. Is that your argument? Counsel. Learned counsel. Tokpe. Okay, I think this line.
Apologies, my lord. If I may.
My lord, sir.
I think his line got hooked up.
Yes, I think so, man.
Because he has used his time, my lord.
Yeah.
Okay, so the network is our timekeeper.
As the court pleases.
The network has voluntarily become timekeeper. I just wanted to clear one point to understand his submissions.
As the court pleases. I just wanted to make a statement in reaction to his submission, sir.
Yes, before.
Apologies, my lord. I don't know the court.
That's Obafemi. Is that Obafemi?
No, my lord. This is Akure.
Eh?
Yes, my lord. Yes, my lord.
So, Obafemi, are you entitled to any response?
My lord, it's just a statement. We filed a reply. I just want to refer, my lord, to what is contained before the court. It's simple. I'm not making any additional argument. Just
you want to refer me to what?
To the fact that the DW2 filed its own compliance with Section 84 and is before the court. DW2 filed compliance with Section 84, which is before the court in paragraphs 19 to 22 of the DW2 witness statement of note. Toluola Bajo.
So, okay.
And the oral identification was to also confirm that the documents referred to in his statement on oath as well. Filed his own compliance with Section 84. DW2 has compliance with Section 84 filed before the court, contained in his witness statement on oath. And the oral identification in court was also to confirm.
You don't want me to record? You don't want me to record?
I'm sorry, my lord. I'm sorry, my lord.
I'm trying to record you. The oral evidence of DW2 in compliance with Section 84 in relation to those documents are found in his paragraph
19 to 22.
Paragraphs 19 to 22. That's a proper guide for me to look at, so that it will be a question of whether those depositions qualify as the oral evidence required in compliance with that section, isn't it?
Yes, my lord. And we further stated, sir. And we further stated that even the oral identification is just to say that, yes, these are the documents I have referred to authenticate that of DW1. My lord will find all of these in his records.
Yes, the oral identification is different from the oral evidence required in compliance.
As the court
aware. Thank you very much.
As the court. Thank you, my lord.
So in other words, you are agreeing with me on behalf of Tope that the submission he was making is that
my lord, I do not agree with it.
No, that the submission he was making is that you did not bring certificate of compliance and you did not make the oral deposition in compliance. That's what he was submitting.
Yes, my lord.
That's why this response, you are now pointing me out where you have done the right thing, isn't it?
As the court places.
Thank you very much. Is Tope back online?
Apologies, my lord, he's not back online.
All right.
I'm trying to get through to him.
I think he has made his case, my lord.
But the court is right to say that was the point he was trying to make, my
Case adjourned for judgment.
Sorry, sir.
To be announced.
As the court places.
I say case adjourned for judgment at a date to be communicated to parties.
As the court places.
As the court places. We're grateful, my lord.
Okay, Learned Suk, sorry for you can call your case.
Thank you, my lord.
Yes.
It's 53-2021, my lord.
Okay. That one that they have adopted, you put it for me. Appearances?
Yes, sir. May it please, my lord?
Yeah.
Honorable Bayo Idowu is my name, sir.
Honorable
Bayo Idowu, sir.
With
SC Odofin.
Is it F-I or F-I-N?
Yes, Odofin.
All right.
Thank you, sir. For the claimant, sir.
Yeah.
Yes, sir. Thank you, sir.
All right. Yes.
May it please your lordship?
Yeah.
Yes, my lord. Dr. Adeola Omotunde. My appearance is for the defendants.
Yes. And you
I'm
appear with
appearing with my learned friend, M.O.
Yeah.
Jimon.
M.O. Jimon.
M.O. M for.
Yes.
Yes, my lord.
Yes.
The matter is for report of settlement today, sir.
Okay. Yes, so what's the report?
Yes, sir. Up to today, despite the fact that we were prepared and wrote letters to them, we have not heard from them. Probably there was any explanation to that from Learned Sick.
You've not heard from the defendant. So what do you want?
If they are not prepared, sir, we go for trial. We go for hearing.
Okay, who is going to determine whether or not they are prepared now?
The defendants, sir. Their counsel
Okay.
and the defendants, sir. Yes, sir.
Okay, so you are leaving it at their discretion, whether in the circumstance of what has happened, whether they are
Probably he has
prepared or not.
explanation, sir. Probably he has explanation to give to Ross.
All right. All right. Okay. Okay. Maybe actually let's listen to the defendant before we ask you what you want.
My lord, I'm grateful, my lord. We had some constraints, my lord.
Okay.
There was a change in the composition of the council of the university.
Are you sure this is the first time I'm hearing this complaint?
My lord, this is the first time seeing this before, my lord. In this case, my lord.
Because this complaint does not appear new to my ears. The only thing I cannot be so certain is whether it was in this case or whether it involved you. There was a change in what? Learned Silk. Why is it that when the council is talking, then suddenly the thing will... Learned Silk. Learned Silk.
Yes, my lord.
Yes, you said there was a change in what?
Composition of the council of the university, my lord.
All right.
The matter was tabled before the old council, before the new change, my lord.
Okay.
My lord, we need time to let them take a decision on this matter. Then we'll refer back to the claimant in this matter, my lord, before the next date of adjournment, my lord.
But are you assuring us that the issue is before the new council?
My lord, it is. It was before the old one. We met together, my
I
lord.
mean the new council. There is a change.
It is before the new council. I'm sure, my lord. I'm assuring the court is before the new council, my lord. It is, my lord.
Before the new council. All
Yes,
right.
So
it's now we can properly ask Bayo, what do you want?
Yeah.
Yes, in that circumstance, we don't want to look as if we are obstinate and the caveat to settlement, sir. So we will give them time. And yes, sir.
How long do you want, Adela?
My lord, we will need about 4 weeks, my lord.
4 weeks from now.
Yes, ma'am.
So you can give us 4 or 5 weeks adjournment.
Yes, ma'am.
That should be after
20th
February. 20th February.
As the God pleases.
20th February.
My Lord, I don't know. We
For further report of
it's okay, my Lord. We'll be there. We are okay
Thank
with 20th February. Thank you, my Lord, sir.
Thank you, sir.
will be determined by then. If it's just report of settlement, it will be soon. No need to ask them to come just for report of settlement. All right, case adjourned to 20th February 2024 for further report of settlement.
As the God pleases.
AK-46 2019. Do you have another Sikh who may want to mention his matter out of turn? No response. So I take it that we don't. AK-46 2019, Mrs. Adebola Ademishola and
Yes.
Federal University of Technology, Akure.
Yes, sir. My Lord, we're in court.
Who is in court?
Good morning, my lord.
Is it the lawyer or the parties?
My Lord, the lawyer is in court and the first claimant is in court.
All right. Appearances, please.
May it please the court.
Yes.
L.E. Udofort for the claimant.
May it please, my lord.
Let me finish.
Aliko, please.
I told you earlier that today is the first sitting for the year. So the engine never warm. We are still trying to warm the engine. When the engine is warm, the brain is warm, the hands are warm, the blood is warm, we can ride faster.
Yes, my lord.
All right. Okay, you announce your own appearance.
Yes, my lord. You, Egbon. You, initials. Egbon is spelled E-G-B-O-N. For the first.
I take a judicial. Okay, your name is also on the screen, but I remember that name very well. I've kept the spelling of the name. Yes.
Thank you, my lord. Yes, my lord.
Are you with someone or you're alone?
I'm alone, my lord. God is with me anyway.
Defendant. The Lord is with all of us. That's why we could even see today.
I'll be called, please. I'm for the first defendant, my lord. There are 2 defendants. First defendant.
Okay. All right.
Yes, my lord.
Yes, who is appearing for the other defendant or other defendants? How many defendants are there? Okay. Who is appearing for the second defendant?
My lord, if I should come in at this point, my lord.
Udofort. No, wait first. Udofort. L.E. Udofort. L.E. Udofort. Okay. Yes.
Yes, my lord.
Egbon.
Yes, my lord.
Anybody been appearing for the second defendant?
There was a counsel that appeared at a time, but he failed to file the necessary statement of defense for the second defendant. But when the matter came up on the 6th of February last year, my lord, 2023, the matter was supposed to go on for hearing. But I raised the fact that
there was no hearing notice, no evidence of hearing notice served on the second defendant since the matter was for hearing. So based on that, my lord ordered that the claimant counsel should ensure that hearing notice is served on the second defendant before the matter is slated or can go on for hearing. So my lord, I don't know whether they have complied with that order.
That's perfect. I made that order on the 6th February 2023, and then we were caught on the 11th October. We were in court on the 11th October 2023.
Yes, my lord.
Isn't it?
Yes, my lord.
And as at then, second defendant has not entered appearance. Yeah. Proof of service. Good effort.
Yes, my lord.
Yes, the second defendant, has he entered appearance so far?
My lord, not to our knowledge.
Okay. What about service?
My lord, we did recall that the court had directed that we left the registry for the defendant to be served, hearing notice.
Yes.
And that last week, we put a call across to the registry to find out what was required of us. And we were informed that it was already.
You mean until last week? We called last in October, and you waited until last week to call the registry?
My lord, we had discussed before now, and the registry said when it's time to issue out hearing notice, they will get us involved. But we didn't hear anything, so I had to put a call across.
Besides, but have the second defendant been served with the originating process?
Yes, my lord.
Can you confirm that? Service of the originating process on the second defendant.
Yes, my lord. My lord, in fact, the second defendant once sent a lawyer to hold their brief.
Yes, that's true. They sent a lawyer to hold their brief.
Without entry.
Yes, NC Olom, or is it Ojomba or Olomba, holding brief of Ihan UF, hour for the second defendant.
Yes, my lord.
Yes, that was on the 6th of June, 2022. That presupposes that they were served. The only problem here is that we discovered that they had not entered appearance in spite of sending counsel to hold their brief.
Yes, my lord.
No proof of service or no process. Yes. Sure. No, the origin, that's the first process that was filed. Was it served on the defendant counsel? Second defendant counsel. Just a moment, let me at least confirm something so that we know the proper order to make, whether I should order that the originating process be served or simply the hearing notice be served. I know that it ought to be personally.
Yes, my lord.
So did you make arrangement for personal service on the second defendant?
My lord, I want to believe they were served.
It's not belief, because here we do with proof, we deal with proof. And what I ask is what you did. Did you make arrangement for personal service of hearing notice on the second defendant?
Hearing notice, my lord. We know that we made arrangements for the process to be served. On the two defendants.
I'm asking you proof of service of the complaint. That's what is originating process. Proof of service of the complaint. So did you make arrangements with the bailiff for personal service?
Of the originating process, my lord. Yes, my lord.
No, even the hearing notice.
Not at all, my lord. When we called.
You didn't make arrangement.
My lord, when we called, they said it was late. And the bailiff never contacted us.
No, it's not for the bailiff to contact you. It's for you to go and meet the bailiff in the court to make arrangements for service of your processes so that matters will proceed. No proof of service on the second defendant. You have still not confirmed to me.
It's not there.
Where is the proof of service of the originating process on the first defendant? If you say that of the second defendant is not there, that presupposes you have found that of the first defendant. Proof of service of claim of the complaint. Proof of service of the complaint. Whatever will show that this person has been served. We have to receive for service on who? How can they not write it there?
I don't know the name of the person that paid for just service to Abuja. Service to Abuja.
Who is the second? Who is the second defendant? What's the address for service? Yes, is at the back. Yes, the second defendant is where?
Abuja.
That is how we connect now. So if there is proof of courier service to Abuja, that's the second defendant. So at least we are sure second defendant has been served. Okay. So I say no proof of service of hearing notice on the second defendant. So Udofort, what do you want?
My lord, in the second. My lord, in the circumstance,
yes,
we are constrained to pray for an adjournment, although we're ready for hearing this morning.
What's my recorded? My recorded.
And if my memory has not failed me,
yes, my lord.
At the last adjourned date, somebody said that we prefer physical hearing. And that was you also.
My Lord, we had said we prefer
on the 11th of October 2023, you said you prefer physical hearing.
Yes, indeed, my Lord. And my Lord,
you have changed your mind?
We haven't changed our mind. It's just that my Lord, we're anxious to get our case heard.
And so in your anxiety or in your anxiousness, you have changed your mind now.
My Lord, we haven't changed our mind. We want the case to be heard. My Lord gave us a long adjournment to today from October.
It is issue of between physical hearing and hearing on Zoom we're talking about.
Yes, my Lord.
You had said you preferred physical hearing.
Yes,
do you
my
now
Lord.
go with Zoom hearing?
My Lord, we don't mind the case being heard on Zoom.
All right, thank you. So what we do now is you make sure you arrange. When I say you should arrange for hearing, for physical service on the second defendant, the idea is as we rise from court today, you will go to the court and arrange for that service. And particularly that you know that the second defendant is in Abuja. As we rise today, you are supposed to go to the court and arrange for service, not to wait until next week is the case, then you begin to call the registry. Please don't do that again.
As a court pleases.
Please. At least within this week, make sure you make time, go to the registry, meet the bailiff, arrange for physical service.
As the court pleases. My Lord will do that.
So what day do we take?
My Lord, sir.
Yes.
Yes, my Lord. My Lord, on my part, I would prefer ordinarily a physical hearing because I know that the witness is going to tender some documents which I need to scrutinize physically and see whether there is a compliance with the Evidence Act. And apart from that, my cross-examination, I want a situation whereby physically I will be cross-examining the witness. Even the demeanor of the witness matters as well during cross-examination, my Lord. But
everybody has what he wants.
Yes, my Lord.
Okay. We have what we want. There is what I want. There is what she wants. But
yes,
the interest of justice supersedes what we want. And the situation now is our court is under renovation.
The court, please.
The court is under renovation. We cannot use the courtroom now. Do we say every matter for hearing should wait until NJC finish renovating the courts? Meanwhile, God has provided us with an alternative. He has given us enough intelligence to create an alternative that we can hear matters by Zoom.
The court, please.
You understand? So
yes, my Lord.
A reaction to situation where we find ourselves that we have to make find a solution.
Yes, my Lord.
Thank you very much.
Thank you, my Lord.
All right. So I say case adjourned to when?
My Lord, what date? We suggest the 21st day of February 2024.
All right.
So let me confirm my diary, please. My Lord, the 21st is not convenient.
What date is convenient for you?
I'm sorry, madam, coming.
And bear in mind that I am not bound by your convenience, the fact that I asked.
Yes, my Lord. I have another case on that very day, my Lord. We have taken the date already. My Lord, the 19th is convenient.
Is that okay, Udofort?
Sorry, 19 is not. My Lord is not convenient.
So I should
can
give
take
my
22nd.
20th February.
It's not.
Okay, 22nd is convenient to me.
All right. Case adjourned to 22nd February 2024 for hearing. Second defendant to be served hearing notice personally.
As the court pleases.
Let me add, claimant counsel to ensure service.
As the court pleases.
Yes. Thank you.
Thank you, my lord.
My lord, I wish my lord a very blessed new year.
Thank you very much. And I wish you the same, and all of us.
Thank you, my lord.
Thank you, my lord.
NEPA has taken their light, so we will get darker here, because even the light was not bright enough. And then they have taken it. Yes, the next one is AK-44-2020, Ogbodo Michael and 35 others, and Ondo State Government and 2 others. Are their counsel in court or the parties? Oh, have we not finished this case? Who the fought? Who the fought? It's her case, so. Who the fought? It's Adeyemi. It's like only one person is left here. Okay, Okopo is no longer here. Only they were discharged.
Yeah. My fault. No, see no. It's really what's the back of open is that it produces law.
Oh, you see, but wait. There were 3 garnishes on the 28th April 2023. I discharged all of them. So that brings an end to the garnishing proceedings. So I don't know why it came up on the 22nd November. No wonder parties were all absent, everybody, because the proceedings came to an end.
Yes, sir.
But let me put it on record now.
Yeah.
Thank you. Good again. No, but the over copying can do the system with copy to know. You see better. If you do download information from a by over copy, open or sell the system on there.
Odeyemi. It's not even Odeyemi. It's somebody that is just his number that is showing. You are talking while you know you are in court. We will write your name as talkative. We'll write your name in the list of noisemakers. We'll put your name there. For instance, dropouts. The counsel in court, please, let's know your matter. Which case are you here for?
The Lord, I'm interested in number AK06 2023. Comrade Afolabi Gani Adeleke. 06 2023, my Lord.
Okay, the other was 6 2022, the one I'm working on. Comrade Afolabi
Gani Adeleke.
Okay, appearances.
May my noble Lord be well pleased, sir.
Yes.
Ola Sumbo Afolabi is my name. And I
Ola Sumbo
Afolabi is my name.
Yes.
Lord. I appear most only for the claimant.
Claimant or claimants?
Claimant with respect, my Lord.
Claimant plus S.
Without S with respect, my Lord.
There is only one claimant?
Yes, my Lord.
Come, I see a lot of writings here. Yeah. All right. Yes, who appears for the defendant?
My Lord, my learned friend Ogunleye Benjamin Alase entered memorandum of appearance and he has filed his statement of defense. Likewise, a notice of preliminary objection in respect of this matter.
Was there service of him?
Yes,
for today. For today. All right. So what do you want?
My Lord, we have we have pending application before this honorable court. It's a motion of notice. We file our reply to the counter affidavit to the notice of preliminary objection filed by the defendant out of time. And we have an application to regularize our position with respect, my Lord.
Okay, that's good. That's good. So what do we do in view of the fact that the defense counsel is not in court today? In view of that fact, what do you want?
Hello, my Lord. Sir.
In view of the fact that the defense counsel is not in court today, what do you want?
In court. My Lord, I want to most humbly apply for an adjournment.
Okay.
Why I equally pray the court that that hearing notice be issued and served on the defendants to let them aware of the next date of adjournment in respect of this matter so that we can.
So when do we come back? When do we come back?
If it pleases me, Lord, I want to most humbly suggest 19th day of February. It's a Monday, subject to the overriding convenience of my Lord, sir.
Case adjourned to 19 February 2024. Defense counsel to be served hearing notice.
As the court pleases, my Lord. I'm most grateful to the court for the indulgence, my Lord.
Thank you.
Grateful, sir.
Any other matter?
Thank you.
AK 33 2021, Mr. Alonge Jeremiah Ibitoye and UBA.
He doesn't have a big phone. That's the one that he doesn't have a big phone.
Where is he in court?
Because he doesn't have a big phone.
Ah, where is he in court?
No, physical phone. NIC.
Who told him only a big phone can do Zoom?
Like he doesn't have a smartphone. He doesn't have a smartphone.
He said big phone.
But it's small. The other phones are small.
Okay, I get the concept of the big and small phone. So for now, it is parties absent. Give me that.
Prince February.
Parties absent, case adjourned to 19 February 2024 for hearing. Parties to be issued hearing notices. Yes, is this?
They already came to
Oh, fine, that's okay. Well, we have come to the end of proceedings for today. Like they have all left already.